Welcome back to the courtroom, where today's case is anything but ordinary. On trial, we have Whitney Mitchell, standing before the judge, not for the first time, but facing the weight of probation violations and a troubling history with drugs and alcohol. Already accused of a second DUI offense, she's now explaining away a failed drug test that revealed cocaine in her system just one day after her arraignment. The defense argues it's old use. The prosecution sees a pattern, and the judge, he's not buying excuses. This case will force us to ask, when does accountability outweigh second chances, and how do courts balance compassion against public safety? You'll see pleas for mercy, a mother invoking her teenage son, and a judge who doesn't hold back when it comes to pointing out hypocrisy. Stick around, because this one escalates fast, and by the end, you'll be questioning if redemption is truly possible in the courtroom. Let's get into it.
Is the cocaine. I did talk to Miss Mitchell about it. She did test the day after her arraignment. She denies using cocaine after her arraignment. This was her first test after being ordered on bond. And her arraignment was on the 17th and the test was the 18th. So her assertion is that it was from prior to given the bond conditions. Regarding her use of cocaine, however, she has seen a doctor at the University of Michigan where she is beginning the process to enroll in treatment there. She has an appointment tomorrow at 2:30, and they are the letter that she provided me that's dated today says that they've spoken with the addiction treatment team and are working to place her into intensive treatment and detox services. And tomorrow will be the follow-up appointment. Regarding the THC, she does have a medical marijuana card and did provide that to community corrections. And
what about her diluted sample? Go ahead.
Yeah, the dilute is the third piece here. I asked her about it. I also tried to get kind of a definition from community corrections. I didn't receive one, but her explanation was that she woke up, didn't eat anything, drank some water, took her kids to school, then went to community corrections, as is her normal routine. She didn't have any insight into what happened, and I don't know why. We both don't know why it would be diluted. We have no explanation for that. She was very clear with me that she did not try to skirt community corrections or anything like that. She said she wouldn't even know how to. So given all that, Your Honor, my request is to keep her out of custody, let her go to this appointment at the University of Michigan, see if they can get her into treatment and detox. She is employed. She has 2 jobs and a young child. She works at the University of Michigan and at Five Guys. How old's your son?
He's not young. He's 15, but 15. I still care for him every day. Drive him back and forth to school, cook him dinner.
That's this individual with, I have a second offense operating while intoxicated at this point on this case. That is alleged to have occurred back in June. And I have a test result that shows up on the 18th as positive for cocaine. Her neck.
This is a critical turning point. Notice how Whitney frames her defense around her responsibilities, her jobs, and her son. On one hand, this is a classic mitigation argument, emphasizing stability and family ties as reasons to avoid jail. But here's the problem. Judges often see it as selective responsibility. Whitney admits to using cocaine and marijuana, but only highlights her son and her work when she's facing consequences. The judge is clearly skeptical, and frankly, so is the audience. Let me ask you, do you think her role as a mother should weigh more heavily than her repeated violations, or should the court focus strictly on her actions? Drop your thoughts in the comments.
This test, though, is a diluted sample.
Can I speak?
Yeah.
So what that was, I wasn't doing any drugs like cocaine or anything. I was smoking marijuana, and then I'm like, I remember I called and asked, is it okay if I can smoke? And they were like, we don't know. Then I found out yes. So I drank some bottles of water before the test, but I didn't do any hard drugs or anything. And I just really want to stay out so I can keep my jobs and stuff. And I can, because if I lose the job, then I won't be able to go to the treatment because I won't have the insurance.
Yeah, it's a horrible circle you placed yourself in.
Yes, it's all my fault.
Oh, it absolutely is all your fault.
I have a problem and I'm willing to try to get it fixed now.
Is that before or after you kill somebody with a car?
I don't,
This is your second offense, or at least alleged second offense.
Your Honor, I don't plan on killing anyone. I really plan on.
Nobody ever does.
Okay, I'm sorry, Your Honor. I just want to stay out for my son and my job.
So when you were doing the cocaine, how much were you thinking about your son?
I wasn't thinking. I was thinking about myself then, being selfish.
So why are you bringing him up now, saying you want to be out with him when you weren't thinking about him when you were doing the cocaine?
Because to see the look on his face when I told him I was coming, and to think to prioritize that stuff ahead of him, and what the good stuff I finally do have going in my life. When I start doing good, I just want to be on a straight and narrow and get clean and stay out. I don't want to have to start from scratch. No, my mercy is in your hands.
Here's the thing I don't get. The test results from June 30th show in her system alcohol, methamphetamine, and cocaine. That's at the end of June, very beginning of July. So you're sitting up here telling me you're sincere about this, invoking your son, doing all of that stuff, yet 3 months later, or a little less than 3 months later, I still have cocaine in your system.
It's an addiction problem.
What?
It's an addiction problem.
So when exactly did you figure that out?
Now I'm going through all this stuff.
Yeah, you want to get here. You're an addict. You're going to get here and try to tell me anything and everything in the world to try to keep yourself out of trouble and keep from being accountable. That's what you're doing.
I just want to keep the positive things going in my life. I'm willing to admit my wrongs.
And here we see the judge deliver one of the toughest blows of the hearing, calling Whitney an addict who will say anything to avoid accountability. That's not just courtroom theater, that's a strategic move. Judges often push defendants like this, trying to pierce through excuses and force honesty. But here's where it gets complicated. Addiction is a medical condition, not just a character flaw. Still, the court's responsibility is to protect the public. So when you've got cocaine, meth, and alcohol showing up in past tests, can the judge really gamble on compassion? It's a moment that perfectly illustrates the razor's edge between justice and empathy in modern sentencing.
Anything else?
Well, Your Honor, I'd ask that you take into consideration the fact that she does have an appointment tomorrow to address.
I don't know what game she's playing. She's playing a game.
If the court does,
If she was really serious about it. I mean, what right now is causing her to do all of this? Being in court? Well, she knew she was headed there from the time that she got stopped on this. And why is it taken over 30 days from the time of her arraignment for her to have this appointment?
I work 2 jobs. I just don't want to lose everything.
and Your Honor, we have been in communication. We talked about this. She's willing to do treatment. I think she's admitted to the court that it would be helpful for her. I agree. On a lot of these cases, it's helpful, right? I guess I'd ask the court to take that into consideration today. If the court does remand her,
I don't know what she's gonna do the moment she walks out of here. I have no idea.
I'm gonna go to work.
I have no idea what she's gonna do. The sad fact of the matter is, I don't think she does either. Because the cold hard reality is, June, she's picked up. She has cocaine and meth in her system, as well as alcohol. So I'm surprised she's not dead. She has a previous drunk driving before that. So between the end of June, so let's just say the beginning of July, coming up into September, she's still using.
yeah,
And then when all of that kind of catches up with her, now I'm going to get myself enrolled in treatment, or I'm going to get myself enrolled in this. But even from the point of the time that she first saw me on the 17th of September till now, she hasn't done anything. Really. She's got an appointment tomorrow. How come that appointment isn't taking place 4 weeks ago, if not 3 or 4 months ago, quite frankly?
Oh. I just worked so many hours and just try to take care of our kid. I should have made it 3 weeks ago, but I'm trying to take.
You got an excuse for everything. Yeah, everything coming out of your mouth is an excuse.
I just want to do better.
if I am able to communicate with the doctor and coordinate some kind of plan moving forward, can I submit that to the court for your consideration?
Certainly you may, but you know, you can have a plan, but then she's going to need to do it. Because I'm going to tell you right now, she's coming before me. She's telling me everything that she's telling.
This moment right here, it's the judge at peak frustration. Whitney has an explanation for everything: work, parenting, treatment delays, and while some of those excuses might be true, courts often hear the same narratives over and over. That repetition makes judges less sympathetic and more hardened against these pleas. Think about it. If every defendant blames overwork, stress, or lack of time, how does the court separate real barriers from manipulation? This is where credibility collapses. And once a judge decides you're not credible, your chances of walking out of that courtroom drop dramatically. Would you have given Whitney more benefit of the doubt? Or do you think the judge's skepticism is justified?
Me, but she's lying to me like she's been lying to everybody in her family and everybody around her for I don't know how long, but certainly over the last year. Well, young lady, game's up. You may have just run into the immovable object. If you're going to tell yourself that you're going to do this, then you're going to do it. But you're not going to come up here and just kind of give me this and that, and I'm going to do this, and this is why, and everything like that. If you want to make a commitment, then you make the commitment, and you got time to think about the commitment. Defendant's bond is hereby ordered revoked. I will adjourn the pretrial hearing to next week on the 22nd, and she can come here with a better plan than what she's got now. 9 a.m. on the 2nd.
And there it is, bond revoked. The judge makes it clear, excuses won't cut it, and Whitney will remain in custody until she can come back with a concrete treatment plan. This case highlights a recurring dilemma in our justice system. How do we address addiction without compromising accountability? Whitney's future now hinges on whether she can back up her words with action. But one thing is certain, the judge has drawn a hard line. And the courtroom drama we just witnessed is a stark reminder that second chances aren't infinite. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next one.